Good morning. My name is Dan Fitzgerald, and this is Susan Hufford. Susan and I are both private clients attorneys in the Greenwich office of Cummings & Lockwood. As Laura said, our topic today is unhappy with the terms of the trust, decanting the problem away. And our conversation this morning is really going to focus on the words that actually appear in trust documents, or commonly appear in trust documents, that describe when and if assets can actually come out of the trust to better help you understand what they mean. Many are of the impression that simply using a trust will protect assets from anything and everything, such as divorcing spouses, creditors, taxes, but it's actually the words that are in the trust documents that are going to tell you what, if anything, a trust will protect against. The hope is after you hear our conversation, you'll be able to better identify for your clients what a trust will protect against. Will it protect against estate taxes? Will it protect against creditors? And if you don't like the terms of the trust, can you decant that trust to a new trust with more favorable terms? We've talked about decanting for years at this seminar, but we want to focus on it because it's really become a commonplace transaction to get rid of old trust terms that you don't like. So with that, we're going to start with a really basic question. We often hear this question from clients, and it's really basic, but what is a trust anyway? What does it even mean to have property in trust?
Well, thanks, Dan. Good morning, everyone. A trust is essentially a form of property ownership where there's a division in the interest in the property between the legal title to the property and the right to its beneficial enjoyment. So to create this division of interests in one property and establish a trust really requires three separate parties. So the first party is the grantor, and the grantor is the person who provides the assets that will fund the trust. And this is done by conveying ownership of the asset to a second party, who's the trustee. The trustee actually holds the legal title to the property in a trust, but they hold it for the benefit of the third party, who's the beneficiary. The beneficiary is the one who gets to enjoy the benefits and the use of the assets, but a beneficiary has no ownership right to the assets. So once established, the trustee then has a fiduciary duty to manage the trust assets on behalf of the beneficiary and in the beneficiary's best interest.
Susan, why do people set up trusts? What are the reasons people use trusts?
Well, Dan, there's lots of reasons why someone would set up a trust, but generally they will fall into three separate categories. The first category would be asset management, and a common example of this, which is found in many estate plans, is a trust for a child until a child reaches an age where they're old enough to actually manage assets on their own. A trust effectively allows for the separation of the responsibilities of asset ownership from the beneficial enjoyment of the asset. A second category is gift and estate tax planning. And we often use trusts in gift and estate tax planning, and I'm sure you all see them in this context very often. Trusts are used in gift and estate tax plannings to maximize gift and estate tax exemptions. And this is done by putting exempt assets into trusts, which then effectively remove those assets from a beneficiary's taxable estate, but still allows a beneficiary the use and enjoyment of the assets. And the third category would be asset protection. Trusts can be used to protect assets from a beneficiary's potential creditors. And this could include financial creditors, divorcing spouses, a lawsuit against a beneficiary. And a trust can even help protect a beneficiary from their own poor financial decisions.
Let's stick on that asset protection point for a few seconds. How does a trust offer asset protection from the creditors of a beneficiary?
Well, Dan, since it's the trustee and not the beneficiary that actually holds legal title to the trust assets, a creditor of a beneficiary can't seize the trust asset themselves. The beneficiary doesn't own the asset, so the creditor can't attach that asset. A creditor can only attach whatever interest is actually held by the beneficiary. So how would you determine what that interest is? Well, when you establish a trust, a grantor normally enters into an agreement with the trustee, and the agreement sets out the rules by which the trustee will manage the assets and the rules by which the trustee will make distributions to the beneficiary. So the level of protection against a creditor will depend on the distribution language that's actually used in the trust agreement, which defines the beneficiary's rights to access the trust funds.
A skilled advisor can normally just figure out why a trust was set up by reviewing the distribution provisions. To illustrate these concepts, we're going to use two hypotheticals this morning. Susan's hypothetical client is going to be an actress we'll call Angie, and my client's going to be an actor we'll call Brad. Angie's parents knew she was an aspiring actress and were concerned about her ability to support herself, earn a living, and manage money. Her parents set up a large trust fund for her. The goal of the trust was to provide a cushion for Angie and not completely restrict her control of the assets. Angie has 15 kids, and she knows how expensive it can be to raise kids, and so she's happy knowing that she has this as a cushion. So the terms of her trust say, my trustees shall pay all the net income to Angie quarterly, and the trust also provides that the trustees shall distribute principal for Angie's health, maintenance, education, and support. And her parents even named Angie as a co-trustee. So Angie and Brad are married, and Angie's sick of his playboy antics, and they're about to get divorced. And she's come to Susan to see what access Brad will have to the trust in the divorce action.
Well, Dan, unfortunately, I would have some bad news for Angie. The trust her parents established is really an asset management type of trust and not really an asset protection trust. Angie's trust directs that she receive all the trust income. This means that a creditor could attach that income interest. The income interest would also be assignable, which means that Brad may argue that all or part of the income should be paid to him, and if successful, a court could actually order the trustee to make income payments directly to Brad. If instead, Angie's trust had said that the income could be withheld and accumulated by the trustee, the income would have what is known as spendthrift trust protection. And that provides that if a trustee is authorized to accumulate and withhold income, it's generally not subject to attachment by a creditor. And Connecticut and many other states actually have a statute that recognizes spendthrift trust protection.
Okay, Susan, I get it. If Angie has to get all the income, Brad could argue that he has to get paid the income as part of the divorce. But the trust here doesn't say that all the principal has to be paid out to Angie. Can the principal be protected at all? Does the trustee have any discretion to withhold distributions here?
Well, Dan, unfortunately, in this situation, the principal could also be subject to Brad's divorce claim. Angie's trust is what is known as a support trust because it provides the trustee shall distribute principal for Angie's health, education, maintenance, and support. This is commonly known by its acronym as the HEMS standards. Although the trustee of a support trust has some discretionary authority over distributions, it's really as to the timing and the amount of the distributions and not whether or not to actually make a distribution. Because of that, a beneficiary of a support trust has a legally enforceable right against a trustee to compel a distribution for any HEMS purpose. And therefore, a creditor, such as Brad, could enforce that right as well. Some other examples of enforceable rights that you might commonly see in a trust agreement that would also be subject to a creditor's claims would be a beneficiary's annual right to withdraw 5% of the trust principal each year, a beneficiary's right to withdraw a portion of the trust assets upon reaching a particular age, and even a crummy withdrawal right that's given for annual exclusion gifting purposes. If a beneficiary has a right to a distribution, then a creditor can access it, even if a beneficiary chooses not to exercise it. But seeing a HEMS standard in a trust doesn't always mean you have a support trust with limited creditor protection. You have to look at all the distribution language that's used in the agreement. For instance, if Angie's trust instead had said that distributions may be made to Angie and the trustee's absolute discretion for health, education, maintenance, or support, in Connecticut, a trustee with absolute discretion, as distinguished from sole discretion, has broader authority over whether or not to make a distribution, even if there is a HEMS standard. So Angie's rights to demand a payment in that type of trust would have been less certain, and therefore so would Brad's. In addition, if Angie's trust had been a sprinkle trust, meaning there were several beneficiaries that the trustee could make distributions to. For instance, if it said the trustee could distribute funds to Angie or her children, then this could have also enhanced the creditor protection because it would have created other parties with an interest in the trust assets and diluted Angie's rights.
Susan, that does not sound good for Angie, but it sounds great for my client, Brad. It's pretty clear that Brad might have some access to that trust in a divorce action. But what about estate taxes? Angie's been successful in her own career. If she died tomorrow, would this trust protect against estate taxes?
Well, Dan, the good news is Angie's support trust would not be included in Angie's taxable estate. As a beneficiary, she doesn't have the requisite ownership or control over the trust assets to cause estate tax inclusion. And that's the case even though Angie's acting as a trustee. These HEMS standards, which are not helpful from an asset protection perspective, are what allow Angie to act as a trustee of her own trust without causing estate tax inclusion, because her discretionary decisions are limited by that standard. But okay, Dan, enough about Angie's Trust. Now we're going to learn about Dan's new client, Brad. Brad's parents were concerned about their son. He was an aspiring actor, and they were concerned he might not be able to support himself. In addition, he was not good at managing money. They were also concerned that he had a gambling problem, and he had shown a very strong propensity for the playboy lifestyle. Because of these concerns, Brad's parents set up a trust for Brad's benefit. But the terms of Brad's trust are a little different than those of Angie's. Brad's trust gives the trustee absolute discretion to distribute either income or principal to Brad. There are no HEMS standards in Brad's trust. But Brad's parents, ever hopeful that one day he'd be able to manage money, also gave Brad the right to withdraw 1/2 of the trust assets when he turned 50 and the balance of the trust assets when he turned 60. Brad's parents also named a third-party independent trustee. They did not name Brad as a trustee. So Brad's coming to see Dan, and he mentions that his wife Angie is not very happy with him, and quite honestly, he's a little tired of all those kids, and divorce is imminent. He's concerned that Angie may try and access the trust funds in a divorce proceeding, and he's wondering if the trust is protected. Dan, how would your advice to Brad differ from my advice to Angie?
Well, from an asset protection point of view, Brad is certainly in a better position to protect his assets from Angie, at least until he turns 50, since that trust agreement gave a third party the absolute discretion to distribute as much or as little as the income and principal as the trustee decides in their sole, absolute, and uncontrolled discretion. Brad has no legally enforceable right to compel a trustee to distribute assets to him, and that means that Angie can't force anything out during the divorce proceeding. It's not to say that the trust would be completely ignored as part of a property settlement, but it certainly offers the most protection because the family court could not order the division of that trust property.
Well, but Dan, even though Brad publicly claims that he's 45, we all know he's actually 55, and he hasn't exercised his right to withdraw 1/2 of the assets from the trust that he's had since he turned 50. Brad has the unfettered right to withdraw that property. Wouldn't Angie have access to those funds?
Can't admit or deny if Brad is 55, but if Brad is 55, as you so allege, and has not withdrawn that 1/2 of the assets, all Brad needs to do is call that trustee and have him transfer it to his own account. The terms of that agreement gave Brad the unfettered right to withdraw the property. So generally speaking, if a beneficiary has the right to withdraw upon reaching a certain age and doesn't exercise that right, the assets are essentially deemed to belong to the beneficiary for asset protection purposes, for estate tax purposes, and for income tax purposes. This does mean that Angie could potentially reach that 1/2 of the assets of the trust in a divorce, and the court could order 1/2 of the property divided. Although the trustee still holds the assets, the trustee is really holding the assets at Brad's direction. So 1/2 would be exposed if he's over 50.
Well, Dan, it sounds like Brad's trust could protect against Angie's claims in a divorce, at least partially, since we can at least agree he's under 60. And even though under 50, it's debatable. But what about estate taxes? Would Brad's trust be subject to estate tax at his death?
Similar to the creditor protection answer, the assets in this type of absolute discretion trust would not be exposed to estate taxes in Brad's estate until he reaches 50. Before 50, Brad has no ownership over the property that would cause inclusion for estate tax purposes. And after age 50, 1/2 would be included in Brad's taxable estate.
All right. Well, but what about acting as a trustee? Could Brad serve as a trustee like Angie can and still have the trust assets protected against Angie or against estate taxes?
If Brad serves as trustee and the distributions are not limited to ascertainable standards such as health, maintenance, education, and support, Brad is going to be considered to have a general power of appointment that would cause the trust to be includable in his estate. I think we've all had the conversation with our clients. They would love for their children to act as trustee of their own trust and have it be protected both from estate taxes and creditors. But to really accomplish both of those goals, the power to distribute needs to be in the hands of a third-party trustee.
Dan, is there anything that Brad could do to change the provisions of his otherwise irrevocable trust that would allow him to protect the assets from Angie in a divorce proceeding and also allow him to serve as a trustee? Brad says he's heard that his trustees could decant the trust assets to a new trust that would change the distribution provisions and help protect the assets and also allow him to serve as a trustee. Is this an option for Brad?
Trustees of Brad's Trust should certainly consider decanting the trust. As I mentioned in the beginning, decanting is the term we use to describe a transaction where the trustee distributes all or part of the principal to a new trust that has new, more favorable terms. So those favorable terms might be for tax purposes, might be for administrative purposes, or in Brad and Angie's case, we might be able to change the dispositive provisions. Decanting is an action taken by the trustee. It's not done by the grantor and it's not done by the beneficiaries, and is subject and governed by a fiduciary duty, so the trustee is risking liability here for taking this action, so it has to be defensible in case it's questioned by a court or by a remainder beneficiary years after the transaction was completed.
So Dan, where would a trustee look to find the authority to do this? How does a trustee know whether or not they can actually decant a trust?
The first place to look for the authorization to decant is the document itself. So many modern trust provisions include a power to decant. A lot of older documents you might be able to find the power. We didn't give you all the boilerplate to Brad's Trust, but if it was a Cummings and Lockwood document, I assure you, in the 46 pages in the back somewhere we would have had a decanting provision. If Brad's Trust does not have that power, the trustees must keep looking for another place to find authority to decant the trust. So the second place to look is a state statute. Connecticut still does not have a decanting statute. New York does. New York has a very useful and flexible statute that allows us to accomplish many decantings. We regularly use the New York decanting statute to decant old stale insurance trusts. The one drawback to New York is that it requires notice to all beneficiaries. If you don't have a statute and you don't have anything in the document, the next place to look would be the state's common law. The premise being that a state's case law might give you sufficient precedent that the trustees feel comfortable that there is a power at common law for a trustee to distribute assets to a new trust. Connecticut still does not have that definitive case that says the common law power to exist here in Connecticut. The most well-known state case is Phipps in Florida. Lastly, if you don't have any other basis, if you have situs change provision, you could always do a little forum shopping, because 25 states now permit decanting by statute. So there's always a pretty good chance, if you don't have the law in your state, we can get the trust to a state that will allow a decanting.
So Dan, this sounds like something that Brad's trustees could find the authority to do, but are there any tax consequences to a decanting that need to be worried about?
Despite decanting becoming pretty commonplace, we still have very little guidance from the IRS with respect to the tax consequences of decanting. Advisors need to be careful to review the pitfalls so clients are at least aware of the potential risks. The IRS announced way back in 2011 that they weren't going to issue private letter rulings until they studied the issue. So in 2017, we got one private letter ruling from the IRS on decanting. That 2017 PLR said that the IRS does not view the decanting of a non-grantor trust to a grantor trust as a recognition event that would cause the trust to recognize gain or loss, which is important. It's also notable that the PLR was silent on net operating losses. For gift, estate, and generation skipping transfer tax purposes, the act of decanting, for the most part, should be viewed an exercise of a limited power of appointment by the trustee. Again, not the grantor and not the beneficiary. So there should be no estate and gift tax or generation skipping tax consequences to the beneficiary or the grantor. It's a little unclear if the beneficiary has to consent to a decanting under a state statute, and that decanting is shifting some sort of beneficial interest, whether that consent would be a taxable gift. For example, if the beneficiary has a mandatory income interest and you're decanting to a trust where that beneficiary no longer has a mandatory interest, has a gift occurred. It's also important for advisors to review the rules with respect to the generation skipping tax, the modification rules, and the GST grandfathered rules. We want to make sure we're not doing anything to jeopardize the GST tax status of those trusts that would cause immediate taxation. And if you're decanting into a trust that already has assets, we want to make sure we're not mixing GST exempt property and non-exempt property. So assuming Brad's trustees can find that authority to decant, if Brad was 48, the trustees could decant to a new trust and essentially eliminate those withdrawal rights at 50 and 60. If Brad is 55, under the New York statute and most of decanting law, that one half could not be decanted, but the remainder of it could be decanted to a new trust. We're going to talk a little bit about Powell Ferry in a second. It came out with a little different result, but we'll discuss why in a few seconds. So Susan, what about Angie? Flipping it back to her, would she be able to decant her trust?
Well, Dan, the trustees could potentially decant Angie's Trust, primarily in order to make some administrative changes to the document, but the options to decant a trust with distribution provisions such as a mandatory income interest or a HEMS distribution like Angies Trust has are very limited in terms of changing the provisions in order to eliminate those rights. But that being said, this brings us to our discussion of a recent Connecticut Supreme Court case called Ferry versus Powell Ferry. And the case was decided last summer, and it received a lot of press as to what it meant for the status of decanting law in Connecticut at the time. And the short answer to that is really not that much. And the reason being that even though it was a Connecticut case, the decanting in question was decided under Massachusetts law, which was then applied in this Connecticut litigation. But the case is worth reviewing because it was kind of a crazy case that made its way through 3 different courts in 2 different states with a bit of a crazy result, and there are a few takeaways from this case to note. So for background, this case was a divorce litigation which centered around a wife's claims to a $90 million trust fund of which the husband was a beneficiary. The terms of the husband's trust provided that the trustees could make discretionary distributions of income and principal to the husband, but there were no HEMS standards. The trust agreement also gave the husband the right to withdraw principal by written notice to the trustees in increasing amounts at stated ages. And after the husband attained the age of 47, he had the right to withdraw all the assets from the trust. Now, it's worth noting here that the trustees were the husband's brother and his father's attorney, and the husband and his brother were involved in business together, and the trust funds had been used to invest in their business ventures. So it's likely the husband had a pretty good idea about what was happening with this trust most of the time, but during the course of the litigation, it was actually established that the decanting I'm about to discuss occurred without the husband's consent or knowledge. So at the time this divorce action was filed, the husband actually had the right to withdraw 75% of these trust assets, but he hadn't exercised this right, so the assets were still in the trust. So of course, in the divorce, the wife made a claim to the trust assets. So in response to this claim, the trustees transferred all of the trust assets to a new trust that the trustees had created, effectively decanting the entire original trust. The new trust eliminated the husband's withdrawal rights and put distribution decisions within the absolute discretion of the trustees. So essentially, they tightened up the distribution provisions to try and protect the trust assets from the wife's divorce claims. So here come all the legal actions. So after the decanting, the trustees themselves filed an action in the Connecticut Superior Court asking the court to confirm that the decanting was valid and that the wife had no claim to these trust assets in the divorce. The Superior Court in Connecticut held that 75% of the decanted trust assets, which was the exact amount that the husband had the right to withdraw at the time of the decanting, had to be returned to the original trust because the husband had already acquired an absolute, uncontroverted right to those trust assets. But not happy with that result, the husband's lawyers appealed this decision to the Connecticut Supreme Court. And instead of answering this question, the Connecticut Supreme Court certified to the Massachusetts Supreme Court the question of whether or not this decanting was permissible under Massachusetts law. So the Massachusetts court actually ruled that the terms of the trust did give the trustees broad enough discretion to permit a decanting, but they also found that the entire trust could be decanted, including the assets that the husband had the right to withdraw at the time the decanting occurred. The court reasoned that since the husband did not withdraw the assets, the trustees still maintained authority and stewardship over those assets, which based on the terms of the trust agreement gave them the authority to decant the entire trust into a new trust that eliminated any withdrawal rights that the husband had, essentially subrogating the husband's uncontroverted right to the assets to the trustee's authority to decant, which is really a questionable result. The court also noted as support for its decision the fact that the husband had not consented to the decanting and that it was done without his knowledge, which is sort of hard to believe given the fact that it was his brother was the trustee and his business partner. But there you have it. So with that decision validating the decanting in Massachusetts, the Connecticut Supreme Court then held that the new trust would not be considered marital property subject to division in the divorce action, but the court could use the value of the trust to determine alimony payments. But essentially, the wife was not going to walk away with half of the trust assets.
Susan, that just doesn't sound right to me, and it's contrary to what I just explained about Brad. So what's wrong with this outcome, and does this give Brad hope?
Well, it's definitely an outlier decanting case. Even if Brad lived in Massachusetts, I'd be careful not to completely rely on this ruling. There was even a concurring opinion by another judge in this case, highlighting the fact that the court was really only asked to decide the very narrow issue of whether the decanting was valid, and it wasn't actually deciding whether or not a decanting in the context of hiding assets in a divorce proceeding was going to be allowed. So it was really a narrow ruling in that regard. But the good news for Brad is that Connecticut did conclude that based on the terms of this new absolute discretion trust, the assets would not be subject to division in a divorce proceeding. So I would suggest that Brad actually have his trustees decant the portion of the trust that he didn't yet have the right to withdraw into a fully discretionary trust, eliminating his withdrawal right. And that should offer him some future protection against Angie's claims. But there were several other potential issues that were raised by this decanting in the Ferry case, so much so that I would not advise Brad to get too excited about protecting the assets he already had a right to withdraw based on that case.
Susan, what are some of those other issues that this case really presented?
Well, the first issue is that it's really contrary to the existing body of decanting law. Most case law and most decanting statutes provide that if a beneficiary has a right to assets, such as a right to all the income or a right to withdraw the assets at a particular age, and that age has already come to pass, that those rights can't be eliminated by decanting the assets to a new trust. This is consistent with the ruling by the Connecticut Superior Court. It's an indication of how a Connecticut court would rule on this issue, and it's also consistent with our advice to Brad. There's also potential gift and estate tax issues with this decision. A withdrawal right, like the one Ferry had, is the equivalent in the gift and estate tax context to a general power of appointment over those trust assets, which means it's the same as having outright ownership to those assets. So the assets funding the new trust are likely to be considered either a gift from Ferry or included in his taxable estate, since he's deemed the owner of the assets in this context. There's also potential income tax issues here. Under income tax law, a beneficiary's withdrawal right that's not exercised or that lapses creates a grantor trust to the beneficiary over those assets. This means the beneficiary has to include income from those assets in his personal income tax return. So under this analysis, the new trust in Ferry should actually be considered a grantor trust to him, which means that he would have the income tax liability on those trust assets, even if he doesn't receive any distributions. And finally, I think there's a self-settled trust issue here. Usually in a decanting, it's the trustee that's considered the grantor of the new trust. But a decanting is not normally done with assets that the beneficiary has a right to withdraw. And under that set of facts, like in Ferry, it seems there's an argument to be made that it's actually the beneficiary who's the grantor of those decanted assets and not the trustee, thereby creating a self-settled trust, which in Connecticut is actually void for asset protection purposes. So Dan, for all those reasons, I would shy away from following the Ferry case until further clarification in Connecticut. But referring back to what I just mentioned about a self-settled asset protection trust, that sort of sounds appealing. Is this something Angie or Brad might be able to set up with their own personal assets to try and shelter their own property from creditors' claims? What is this kind of trust and how would it work?
A self-settled trust is a trust where the grantor is also a potential beneficiary. Connecticut and New York have made it very clear that self-settled asset protection trusts are against each state's public policy. These states will not recognize spendthrift or asset protection where the grantor is also the beneficiary. This means, for example, a Connecticut resident cannot set up a Connecticut trust for their own benefit and have those assets protected from creditors. While some of you may agree with Connecticut or New York and be repulsed by the idea of a self-settled asset protection trust, there is some logic behind the idea. For years, spendthrift statutes have protected inherited wealth as long as someone else set up a trust for someone. So why would the law protect inherited wealth over wealth that was earned, saved, and set aside as a rainy day fund by a wealthy person? That person who has earned significant wealth should, at a time that he or she has no known creditors, be able to put assets into trust and retain an interest, and at a future date have those assets protected from creditors. So a lot of American states saw the rise of foreign asset protection trusts and thought there was an opportunity to stimulate their economies by changing their trust laws to create what we now call domestic asset protection trusts. There are 17 states that recognize domestic asset protection trusts. Each state's the law varies a little bit in each state, but generally each state now permits a person to create a trust, retain a beneficial interest, And if certain conditions are met, those assets will be protected from claims and creditors. So how does a Connecticut or New York client go about setting up these trusts? The grantor has his lawyer draft a trust agreement that names a trustee located in that state. The trustee has the exclusive power to administer the trust in that state by keeping all the records in that state. The trustee must sign off on all the transactions. The grantor can give the power to distribute back to the grantor, his spouse, his descendants. In the absolute discretion of the trustee, there should be no health, education, maintenance, and support standards in the document. And the trust agreement should also choose that state's law as the law governing the trust. So given Connecticut and New York's public policy, can this used be effectively in Connecticut or New York by a resident of these states? There's been some recent cases and a law review article that have pointed out that a resident can still use these to avoid creditors in these states if the creditors cannot get jurisdiction in the local courts over the trustee or the trust assets, making them effective even in the face of public policy. In order to get jurisdiction over the trustee, that trustee has to have some sort of minimum contact with the state. In order to get jurisdiction over the assets of the trust, the assets must be located in states, so New York or Connecticut real property or New York or Connecticut corporations. Some of you might remember con law or constitutional law. The full faith and credit clause should apply, right? A judgment in one state should be enforceable in another state, but the full faith and credit rules actually allow that local state's law to rule the collection procedure. So each state that's adopted an asset protection statute has also changed their collection procedure as to trusts to make sure they minimize the impact of the full faith and credit clause. And so the key with these asset protection trusts is really it needs to be set up before there are any known creditors. There's a known creditor, you risk that any transfer would be a fraudulent conveyance. So if you have clients that are in high litigation risk professions, they can think about this as a potential to possibly protect assets or at least provide some leverage in a negotiation. So if you're a doctor and that malpractice suit has already been filed, it's too late. If you hit someone on the way here this morning with your car, too late. And for Angie and Brad, who are about to go through a divorce, it is too late.